Let's welcome Qanun, the law and order of life. Qanun here on Salam India is presented to us by attorney at law Mr. Raja Bhandari of Saxon Settlements. Today, this popular attorney will give us vital information on the power of attorney. Let's have a look.
Good afternoon. This is Raja Bhandari from Law Offices Raja Bhandari and Saxon Settlements. Welcome, friends, to Qanun. It is your own segment, your questions we are trying to justify with our answers. We are talking about estate planning, always will, trust, or estate planning and related document. Let's talk about the living will. The question came up again. I already described very much in detail last time. However, living will is basically a medical directive or a physician document that you put your wishes according to your needs, according to your health, that this is exactly you want to be treated after you get sick or you are no more. So most of the time, the living will or medical directive, we prefer that you should forward that to your physicians. Sometimes wishes are that two physicians should be consulted if something happened in case of vegetative state or incapacitation, that after that they decide that you are not going to be healthy afterwards, modestly speaking. So that way they can pull the plug with consent of your family. Of course, you will be putting that in the living trust. This particular document is very important document these days. As you know, that certain hospitals will not check you in when you are sick, and then you got to have a document and you have to have a permission to handle your body and as well as directive to your physicians in case something happen. This is due to liability also and due to your wishes also. So many things include. But keep one thing in mind. The documents, healthcare directive, living will, if you have a old document, let's say before 2004, please make sure that you revise one, because HIPAA came into effect afterwards. Your beneficiaries, your family will not get medical records for that matters if you do not have that particular provision in that document. So please make sure you consult an attorney of your choice if you have a documents before 2004, because there are so many changes afterwards. So we were talking about living will. So living will, basically, as I mentioned, that this is a part of the estate planning when we prepare a trust. So it is one of the document along with a healthcare directive. Living will is there, and then of course we can call different names. So that way you appoint your family, your physician, or anybody for that matter that can have a power on your wishes as far as health is concerned, as far as your body is concerned, not the financial. Of course, financials are related to that, that is different story. Then you have a regular document which is we call durable power of attorney that can handle that. Of course, remember that living will is also goes with you, because most of the time will is because we don't differentiate between will and living will. Living will is also effective while you are alive, because if you're sick, you're not died yet, but at the same time you're sick, they're still in effect. Will is only comes into effect when you're no more. Living will is a different document. Of course, it's a living will. That's what you have to differentiate, that your wishes during you are living or afterwards also, that this is how I've been doing. So these are the difference between both wills. Now, friends, we will be talking about power of attorney. This is a very important issue. When we prepare a trust agreement, estate planning, we have a different power of attorneys. The very important power of attorney between the spouses is the durable power of attorney. Durable power of attorney is basically that it can manage your affairs as far as finance is concerned, as far as anything related to your property, related to your bank accounts, related to your security deposit, related to your security instrument, your banks, anything, personal property as well as real estate property. So you give power to a second person, which can be your spouse, which can be your daughter, son, brother, sister, anybody, or a out of the box anybody like us as an attorney, that someone appoint us as a attorney in fact, which is we call agent also, for you, that in case you are sick, you are incapacitated, or you are not available, then we can manage your affair according to your wishes. But keep it in mind, when you prepare a durable power of attorney, you make sure that you pick a proper and durable, as I said, durable, a trustworthy agent. That can be, it's not I'm saying that your family cannot be trustworthy, but sometimes they are not capable of handling the situation. They are little easygoing. Your agent, your attorney in fact, that's what we call, should be very responsible, trustworthy person, because you are giving your powers. Whatever you can do, they can do. That's how it's going to be in the durable power of attorney. So if you are assigning your powers to third party, to attorney in fact, make sure that you have a trust in that person, and that person should not take you for a ride or should not give you a situation that you will not feel comfortable. So friends, I will be talking more about on the power of attorney, because there are different kind of power of attorneys. Time is up for today. Thank you so much, taking a leave from you. This is Raja Bhandari. So long.